Judge, you want me to bring Paris Williams?
Yes, sir, please. And Alexis Johnson.
Okay.
And Mr. Tolles will get to you. Miss Freeman, Mr. Lewis came online while you were in, I think, speaking to Mr. Tucker. And he does not object to a continuance in this 7-defendant case.
Okay.
I'm gonna speak with you, and I think Ms. Pleasant has a co-defendant, and we have Ms. Schoolcraft
And Mr. Tolles.
and Mr. Tolles. And because I think the way that things are currently situated, it's like herding cats to try to get 7 attorneys in the same space at the same time. And so I may have to specially set the individuals. My inclination is to go ahead with the hearing on the persons that are lawyers that are available, and then specially set the other cases. But I'm going to leave that for a discussion before I make a final decision.
Judge, since you're on YouTube, we can't see you.
Oh. Thank you. It's so much stuff moving around. It's like I can't even pay attention to basic stuff. Are you Mr. Paris Williams? Okay. Mr. Williams, there's an announcement from the state that the officer is not available to testify here today. And there's been a motion made by the lawyer, Ms. Pleasant, for Ms. Johnson to dismiss charges. And I'm going to grant that motion to dismiss these charges. And paperwork will be filled out at some point in time, probably today. But what you need to know is that the fact that I'm dismissing the charge here today does not mean these charges cannot be brought back. The state has approximately 4 years from the date, generally from the date of the offense to indict the case or to accuse the case. But as it stands today, this case is going to be dismissed against you. And it will totally be within the powers of the district attorney whether they choose to go forward with these charges. Do you understand it, sir?
Sir.
Do you have any questions about that?
No, sir.
Okay. All right. You're free to go back. Do we have Ms. Johnson?
Yes, Judge. Come on. Come on.
Ms. Johnson, did you hear what I said to Ms. Williams?
Yes, sir.
So a motion has been made by your attorney, Ms. Pleasant, to dismiss these charges, and I've granted that motion. And so the same thing applies. The state has approximately 4 years to bring these charges back, and they totally have the power to bring it back through an accusation or indictment. But as it stands today, these charges are going to be dismissed. And so the decision to move forward on this case will solely be the decision of the district attorney as to whether they choose to go forward. Do you understand that, ma'am?
Yes, sir.
Do you have any questions?
No, sir.
Okay, so we'll complete the paperwork today for yourself and Mr. Williams, and when the jail receives the information, you will be released, assuming there are no other matters that are holding you within the custody of the sheriff of Clayton County.
Yes, sir.
Okay, ma'am, you're free to go back. And so, Ms. Freeman, just so I'm sure with Mr. Williams, He has two charges, 2021 CW 55538 and 2021 CW 55539.
Yes.
Thank you, ma'am. Okay. Now,
And Judge, I have an update and I see Attorney Christopher Harris is on, and so you may want to address this. So my legal assistant was trying to get a hold of the officer, Mr. Green. So we would be getting ready and we are unable to reach that officer. And so, and just so the court understands kind of our process. So my legal assistants work to contact officers a week in advance. And so when I announce that the state's ready, that's based on when they would have contacted them before. And so the day of the hearing, when they try to reach out to them to let them know, hey, your case may be a hearing. So that's when, like, as now I'm coming back saying we can't get a hold of the officer. You know, as in the past, sometimes the officers who have worked certain shift, maybe sleep. I don't have explanation, but with this particular officer on Green, we cannot reach the officer. I am asking for a continuance, and the case has been continued before one time, but it was requested, which is listed on the continuance form. It was at the defense request. And so I believe this is what, I don't believe Mr. Harris, I don't know if Mr. Harris represented Mr. Green at that time on February 23rd. But the continuance that was done by Judge Case Johnson indicates it was at the defense request. And so at this time, the state is asking that it be rescheduled because we don't have our officer.
let me ask this question. I'm assuming, and correct me if I'm wrong, that the WA 2022 WA 01493 says obstructing an officer. Was that felony obstruction?
It's a felony obstruction. Yes.
Okay.
It is a felony obstruction.
Okay. And when was the person arrested?
It looks like on January 11th.
Your Honor, I'd like to address the request for the motion for continuance when you get a chance.
Yes, sir.
Your Honor,
I'm all ears.
Your Honor, I would normally go along with requests to continue. However, when I have a client that's currently incarcerated and the prior continuance is based on him looking to secure counsel, and I was his previous counsel for the offense in which he was in court and taken into custody on a VOP for which these charges stem from, he wanted to make sure and have me secured for his representation at the preliminary hearing stage of this case, which has been done. But the continuance at his request obviously necessitates a choice by him and his desire to remain in custody until such time as he could have that hearing heard. That's obviously resulted in a delay of his potential freedom. And we're here before the court now, and the request that's being made, whereas I normally would not object, I have to take issue with it here. If the officer is not validly under subpoena, there's no lawfully submitted leave or basis for continuance in this case. Any further delay or continuance would result in my client having to potentially remain further, incarcerated. Whereas even though he's incarcerated now on an unrelated matter, he doesn't need to have those things stacked to the extent we're working to try to address his other basis for incarceration. So we'd ask that not denied and that the matter be dismissed for want of prosecution. Obviously, the state can always come back later and indict or accuse at a later time.
Okay, can we bring Mr. Green up? At the jail, can we bring Mr. Green up?
Yes, Judge, we're bringing him up.
Okay, and when Mr. Green comes up, Ms. Freeman, I'll let you respond what Mr. Harris just said.
And just for some clarification for the court, he's currently under sentence with his VOP was for essentially just over 2 years of time revoked. as of that January date when we had the BOP hearing. So absent any kind of change in that sentence, he's got 2 years for which he would be serving in state custody. This is the only matter holding him in county custody at this time.
And you're saying VOP as in violation of probation?
That's correct, Your Honor. Felony violation of probation case for which he was revoked and given slightly over 2 years, the balance of this sentence to serve in state custody. These charges here, which bond has not been made, are the only charges keeping him in Clayton County. Otherwise, he's just awaiting DOC to come pick him up and take him to begin serving his other sentence. So, you know, like I said, the state can always come back and indict and accuse later. It doesn't mean that he's going to be released in the event the court has any kind of concerns about granting our request not to continue the case.
Okay, Mr. Green, have you heard the conversations that have taken place up until now?
I just got right now, so if you can say it by phone one more time, that'd be cool.
I'm sorry, sir, I didn't understand you.
If you can repeat it to me, please. I just got right here.
Okay, so we're at a point where your lawyer has made a motion to dismiss the charges because the police officer is not available at this moment. And so I have that information, and Ms. Freeman, who is representing the state, she has an opportunity to give a response to your lawyer's statement. So Ms. Freeman, I'll let you speak.
Thank you, Your Honor. The state is asking that the case be continued. The first time the case was continued, it was at the defendant's request. And so in all fairness, the state is asking, this is the state's first time requesting this. The officer is unavailable. The defendant, as attorney indicated, the defendant was sentenced or has a little over around 2 years to serve. And so this certainly is not the only thing that's holding him. I know he's waiting for the Department of Corrections to get him, but certainly these charges are not standing in the way of him being released from custody. The state is asking for a one-time continuance.
Let me ask you this, Ms. Freeman, would it give the potentially give the state more freedom if I dismiss these charges today and he goes into state custody and the state were to either through an accusation or an indictment secure that avenue, he would not get released. He would just come back to Clayton County to face the charges if the state decided that that's what it desired to do.
Well, it depends, Judge. So sometimes if a person is already with the DOC and not in the custody of Clayton County Jail, and we file an accusation or the person is indicted, sometimes that person here to deal with his or her charges until he or she has completed his sentence with the DOC. So I can't say with 100% certainty that as soon as the case is indicted or accused, that he would be brought back to to Clayton County. If he's, like say if he's in Jackson or somewhere like that. So, because I've seen it both ways. And I've had attorneys contact me and ask, can we pick the defendant up because he or she wants to handle everything at one time so they can serve essentially one sentence to resolve all the cases. So I can't say that he will automatically be brought back as soon as the case is indicted or accused.
And, Your Honor,
I'm sorry, go ahead, Mr. Harris.
See, I've done quite a few of these things with different jurisdictions and always having to deal with DOC and trying to get individuals produced for court. And my experience has been that DOC, unless they change their policy, unless someone's already at Jackson for pickup, If he does stay at Jackson and there's an indictment or an accusation and he needs to be brought back for a court appearance, that should not be an issue for retrieval. However, if he's sent to another facility to serve a balance of time before being paroled, that they are doing those, that I would have to coordinate appearances, not through production orders, but through their online virtual system for WebEx appearances with the court, which obviously is more work and complicated on our end and would potentially delay the case moving along up in Superior Court if he stays in custody. But the flip side of that is leaving a bond in place and having a preliminary hearing seems to not be in the best interest of judicial economy and justice when it just delays and stalls his ability to get down the road to potentially start getting consideration from the DOC as to when he should be released. So it's we would say we would again renew our request to go ahead and to dismiss the case based off of one of prosecution at this time, and to the extent that he's going to be in custody. He received a slightly over 2-year revocation of the sentence, Your Honor, which only he'll get some light credit, a month or so worth of credit for time served from before his date of adjudication in January, but he'll still serve a good chunk of time before they decide and make a determination on parole eligibility.
And Judge, one of the charges is a felony obstruction. It is a serious charge. We would ask that it not be dismissed. And again, the state did not request a continuance the end of February. This is our first time. And I am asking that the court give us a new date.
Just say I did not request that.
So, hold on.
Mr. Green, hold a second. You have a lawyer. I'm gonna listen to your lawyer, sir. Okay.
If Mr. Green wants the consent continuance just to have the prelim, then I don't have any issue with it. I don't know if that was what he was trying to say, but my standard policy and position is always to dismiss upon non-appearance of an officer to pursue, support the
Okay,
prosecution.
I did not understand what he said. Was he asking to have the case continued? And okay,
Sir, no, last time I came to court, it was a misunderstanding with the public defender, and he continued. I told him I wanted to go along with it, but he continued. That wasn't my choice.
okay. So, are you asking for this case to be continued?
Sir, no, sir, I don't. I want to go ahead and handle it today.
Okay.
Okay, if I can. I got a
Okay.
child on the way. I just want to get my child.
Well,
Okay.
and Judge, I had previously, when Attorney Harris was on, I'd made a couple of offers to him. And so I don't know if this time, if he may want to have a breakout room with Mr. Green to discuss those, to see if maybe that's a possibility. Otherwise, I'm still asking that the case be rescheduled.
I was anticipated the potential offers from the state. I previously discussed those with my client. Even if accepted, would serve to only complicate potential parole eligibility, and we also take issue with some of the factual allegations in this case. So we are not in a position to accept the state's offer as made, and again, insist on a hearing. And frankly, if state can't prove today through lack of the witness, they're not foreclosed from pursuing it at a later time.
Okay. The thing that I was thinking about was just my understanding of the interstate agreement on detainers, meaning that if Mr. Green is in custody, if he's in DOC's custody and there's either a warrant that's outstanding or an indictment that's outstanding, that he would have the opportunity to request to come back to Clayton County and deal with it. Or he would just wait until his time is up as it relates to whatever sentence he's under, and he would be brought back to Clayton County to deal with it. It appears that in any event, this is going to be something that's going to have to be dealt with. So I'm inclined to not grant the request to dismiss these charges. Ms. Mary, would you place this on the next available preliminary hearing calendar to be heard? And I don't have an officer listed, Ms. Freeman, on my calendar. Do we know the name of the officer?
Yes, Judge, it's Officer Ryan Jackson with Clayton County PD.
Your Honor, next week is a very heavy trial calendar for me, prospective jury trials in a couple jurisdictions and then other courts mattered in between. But the following week is much more available if the court would please take that into consideration.
Yes, sir, Mr. Harris. I think right now we're looking at least the week of the 21st.
28th.
28th.
Mhm.
So we're looking at the week of the 28th.
That's fine, Judge, if we can have March 28th.
That would be fine for me. I do have a couple, one moment, I'm sorry. I should be available, Your Honor. It looks like I have no actual conflicts that day. Though I had two, but they look like they're going to be resolved. So that should be fine if it's the 28th.
Okay, and I don't have any information as it relates to the facts of this case, but it would appear to me that this is something that possibly can be worked out, given the information that you've given me today, Mr. Harris.
Right. I've extended an offer to the state as far as the best offer that my client's willing to accept absent trial.
Well, and Attorney Harris, just, and I don't know if you understood, you were trying to make an offer to me. That's not, that would have to be made to the ADA on the case, trying to get the whole thing resolved. From my end, at this level, I make what we call fast track recommendations. And so what you're asking for, that's something that has to be dealt in the courtroom. That is not something that I deal with.
I understand. If you can't amend one of the charges based off of its position now, then that's understood. We can discuss it post preliminary hearing. I will with someone in your office.
Okay. Thank you, Ms. Harris. You can be excused and Mr. Green can be sent back.
Thank you, Judge.
Thank you, Judge.
Good to see you. And just to correct something I thought I saw earlier, did Ms. Boulware Pleasant switch from the dark side to the light side? I'd never seen her representing someone as defense counsel before. Were my eyes deceiving me? Or was that-
Wow.
Good morning, Mr. Harris.
I first met Miss Pleasant as Miss Boulware my first go around, and as a magistrate.
Judge, we're on YouTube. We're still on YouTube.
All right, I'm sorry.